of resolution for his removal from the office of the Speaker is pending would appear to be unfair. If a Speaker truly and rightfully enjoys support of the majority of the MLAs, there would be no difficulty whatsoever. To demonstrate the confidence which the members of the state legislature repose in him. Well, let's just pause here for a minute. Well, if these disqualified members are disqualified, then they would not be in majority. Then this consequence would not happen. Right. The office of the Speaker, with which the Constitution vests the authority to deal with disqualification petitions against MLAs, must surely be a Speaker who enjoys the confidence of the Assembly. After all, disposal of the motion under 179C would take no time at all. Well, I don't understand this statement either. It can take 6 months. If you issue the notice, just after the session is over, and the next session is within 6 months, it takes 6 months. Which means there's a hiatus in the functioning of the constitutional authority. So how did the court say it will take no time at all? It will take no time at all if the leave is granted in the House and the resolution is put to vote. Then it's no time at all. So my argument before your lordships is going to be the following. Let me state by state that a notice for removal of the Speaker should only be moved when the House is in session. That will prevent, all this malpractice that takes place. It's a proposition, that my learned colleague, Devdat, suggested to me, and I found it appropriate. Otherwise, what happens is, that you can topple governments at your will, knowing the nature of our politics. But if it is allowed to be moved only when the House is in session, and if leave is granted and within 7 days, it has to be put to vote, then none of this will happen. Then the 10th schedule, will be allowed to function. And also, the Speaker, when the resolution is passed, till such time as the resolution is passed, he continues to be a Speaker of the House. He only vacates his seat, when the resolution is put to vote.
Otherwise, according to the consequences, the moment a notice of resolution is issued, he becomes disabled.
Yes.
And it's a constitutional office.
Yes, it's a constitutional office. There can be no hiatus. There can be no pause.
That notice has no resolution. Rules of the legislative assemblies indicate how many members have to move a notice.
29.
29. All assemblies.
No, they are different. Rajya Sabha is different. Lok Sabha is
29 is the number under the rules.
Yes, under the rules of business.
So then
it's 10%. 10%.
Where does the 10%?
Where do you get that?
Under the rules.
In the
Rule 11 says 29.
Oh,
Rule 11.
Different assemblies will have a different threshold.
Yes. Every assembly will have.
Every assembly would have a different.
There's
no uniformity. No. For example, in Rajya Sabha, in Lok Sabha, it's 50.
Oh,
Rule 20. Rule 20.
When notice can be given by one person.
Which rule is this? Rule number?
Rule 11. Rule 11.
In this
It is what you're saying. It's not. The whole process, according to your submission is, should be completed in that session.
That's right.
No, the concern rule, you're answering a lot of questions. Concern rule is at page 40.
Page
Page 40, statute compilation. My learned friend is right, the figure used is 29, but the logic is 10% because the membership of this house is 288. So the nearest round.
So Rule 11 says 10%.
It is not notice, it is leave to move the resolution. Notice is by one person.
Correct. Unless it is supported by 29 MLAs, correct? It is not a resolution at all.
Yes, not only that, but he may not move it.
And only-
I sent, but what has happened in this case, that resolution has never been passed, 8 months have passed. He only did it to ensure that the speaker doesn't act under the 10th schedule. But today, let's talk of this case. That notice was never moved.
No, according to you, notice is never put to vote. Only the resolution is always put to vote.
No, notice may not be moved at all. You may issue a notice, one member, and the one member is common in every assembly rule. Manoj. In every rules, in all rules of business, Manoj, of all assemblies in this country, including parliament, one member can move. See the consequence of this. He may move and he may not move it when the session comes up. He may just drop it. Or he may not get leave.
So he may serve the notice even not when the legislature is not in session.
That's right. He may not serve when it's not in session. And see the consequences. And they are doing it in every case now. We also did it in this case, but that's the objection my learned friend took. But when we realized that he was going to disqualify us, kindly see what has happened is, Manoj, that the speaker has only issued notice to us, that is the Congress, that the MVA, for the disqualification of their members. He has not even issued notice to them on our disqualification, till date. And then my learned friend's argument is, go to the speaker and have it decided there. What is going to be decided? He's not even issued notice in our matter.
8 months.
8 months have passed. That's why I said on undisputed facts, Manoj, violation of the 10th schedule 2.1a and 2.1b is ex facie proof.
So really speaking, there are two thresholds. One is the 14-day notice.
Yes.
When you give the 14-day notice, the House doesn't have to be in session at all.
Yes.
Because it can be even before the House assembles.
Yes.
And once the 14-day notice is given, then Rule 11, which is at page 40 of the statute compilation mandates,
Yes.
that thereafter, not later than within a period of 7 days, thereafter, he will request the members who support the notice to rise.
Yes.
And if more than 29 people support it, then leave is granted to move the motion for...
He may still not move it. He may still not move it, Manoj. It's only leave that's granted.
Right.
So member may not move it.
So, Manoj, what will happen is, Manoj, that it will be fixed in the House within 7 days as an item on the agenda, resolution of moving. But Manoj, this is where the assembly, for the movement of the assembly, how does Manoj, till such time, the resolution is actually, Speaker is conducting his affairs in the assembly. He is not prohibited either under the Constitution or the rules of business not to sit in that chair, even though there is a motion, there is a notice, and there is leave. He only vacates his chair at the time of voting. So, but as the assembly goes on, but the 10th schedule is paused, constitutionally paused by this judgment.
And it is after leave is granted that the motion has to be then taken up within a period of 7 days.
That's right.
So the first threshold really, I was just reading Rule 11, says that the motion to remove the speaker is to be given, of which 14 days notice is required under Article 179. That's the Article 179 threshold.
That's correct.
That is given. Then as soon as maybe after the expiry of that 14 days notice period, it would be read to the assembly by the speaker. The
Correct.
speaker said, well, those who are in favor should rise. If 29 people rise, then leave is granted.
Yes.
And then within 7 days thereafter, a motion to
Absolutely.
remove the, that's
the process.
That's the process.
That's the process.
Part of it is constitutional, the 14 days requirement. But the rest of it is legislative assembly procedure. Of course, that's also rules made under the Constitution.
That's correct.
Now, Nebium says that the moment the notice is given by an individual,
Yeah.
you are then disabled. The speaker is disabled from functioning.
As a tribunal, not otherwise in the assembly.
He performs all his
All his functions in the assembly. So how can you have an interpretation of the constitution where the speaker against whom there is a notice for removal functions in the assembly but can't function under the 10th schedule?
So according to you, at what point of time is the disability attached to the speaker?
There is no disability.
There's no disability according to you.
No.
Even after the 29 threshold is crossed and leave is granted to move a resolution, according to you, there is no.
There can't be, mother. Still can't be because the resolution may never be moved.
Unless the resolution is put to motion, put to vote.
Exactly. And mother, the reason is why there cannot be no hiatus. Because mother, there must be somebody in the tribunal to deal with disqualification petition. So you can't say that between the leave and the resolution, he should not function. Because the Constitution doesn't allow a pause, mothers, in the functioning of constitutional authorities.
Once leave is granted, Mr. Sibal, once leave is granted, the discretion to move the motion is still with the member who is moving the motion.
Yes.
So he may not move the motion at all.
We not move it.
Is it that after the leave is granted within certain days, the motion is to be moved?
7 days.
Actually put?
7 days. 7 days.
7 days.
Suppose it is not moved by the concern, it will lapse.
Absolutely.
But if he stands by his motion, the speaker has no option but to move it listed within.
Then Article 181 says he must actually move from the chair, become in the. Well, then what happens? Very interesting. The
Can we just see? I mean, let's keep Nebam. Let's look at the Constitution for a
Yes. 179.
It's always better to apply our mind.
Always better. I agree. I always tell my colleagues, Millet, read the statute before you go to judgments.
That was Justice Frankfurter's great advice, right?
Yes.
There are 3 principles of interpretation. One,
Every time you read the statute of the
the
Constitution,
second, read the statute, and the third, read the statute.
That's right. Something new emerges.
Let's read the.
Yes, I'll read 179. A member holding office as Speaker or Deputy Speaker of an Assembly shall vacate his office if he ceases to be a member of the Assembly. May at any time by writing under his hand addressed, if such member is the Speaker to the Deputy Speaker, and if such member is the Deputy Speaker to the Speaker, resign his office. And the third C, may be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly.
So according to you, really the disability attaches to a removal.
Yes.
And until there is no removal, there is no disability. There is no Constitution does not contemplate a hybrid situation.
Either as a Speaker of the Assembly or under the member.
Or under the 10th schedule.
In the proviso.
Yes.
Provided.
Provided that no resolution for the purpose of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further that whenever the Assembly is dissolved, the Speaker shall not vacate his office. That's we are not
First
concerned.
proviso.
Now kindly see 181. But the second proviso was also important because the Speaker is a continuing. Shall not vacate his office until immediately before the first meeting of the Assembly. Shows no pause, as I said.
So this, at least 14 days notice of the resolution is given is now regulated by the rules of procedure, which says first 14 days of the notice.
Yes.
Then the leave is to be granted.
Right.
And thereafter 7 days, a period of not more than 7.
But some problem may arise. For example, nowadays, we see diminishing meetings of sessions in in Parliament and in the assemblies. Well, it's budget session, sometimes in some state assemblies is only 5 days, or only 7 days. So where do you get the 14-day notice? That's the other problem. We have to look at it, the ground realities, Manoj. The Constitution says 14 days notice because the Constitution makers never imagined that we will make the assemblies redundant by not meeting at all. But the whole process has been polluted now. We never thought. I'm not saying now. Look, I make no political arguments in court. I've said all governments. Remember, I made all those views all over. So there's no politics in this. See, this is for the country, for democracy. This is not for A or B. We come to power, some other party comes to power, they'll misuse it. They'll use it to your disadvantage. So let's not get into that.
Read 181.
In this case, even the 11th position has not reached, is your argument.
Yes. And this is what is happening, Manoj. So you won't get the 14-day notice. So then how will you remove him? Now, if you have the 14 days notice, even if it is earlier, Manoj, then you can't say he's disqualified.
Second proviso, it's a very
Yes.
interesting proviso.
Yes.
Provided further that whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after
Correct.
the dissolution.
That's correct. It's a continuum.
Speaker continues notwithstanding the fact that he was elected through the assembly
That's correct.
until the new assembly takes
Even in dissolution.
even in dissolution.
Then what happens is that the speaker vacates his office in the next session when it is reconvenes, Manoj.
The pro tem speaker.
And then the pro tem speaker, the oldest member of the house normally, is then presided over them.
This was relied on by Venkatachilaya to uphold the position of a speaker, saying that he has got nothing to do with the political party, his objectivity is there, despite the house speaker continues, so therefore, we can trust the speaker as the arbiter. That's
Whereas we've seen that trust, Manoj, we've seen that trust being used and
That's
misused.
the
Gulzari Lal Nanda.
the argument was rejected in this.
Mr. Nariman and my argument was this is unconstitutional. Don't give it to the speaker. But because it was rejected by 3-2. But I think the time has come in your Lord. I really think so, because this is not about this case alone. These are quintessential questions which will, on the basis of which democracy will survive. Otherwise,
Then give it to the speaker, then who will decide?
the court.
Why should the court? It's a matter for the house. That's
I know,
that
that's-
argument was also
That
rejected.
is exactly what Justice Sabharwal says in
Was
Judgements.
that we court should not, because it was argued saying that court can't get into the house to decide.
And ultimately, if you say that this is unconstitutional, then you completely throw the baby out with the bathwater.
Yeah, but-
There's no disqualification.
Well, there is no bathwater left at the moment, Manoj.
It's an endeavor of
Well, otherwise, if you say that, well, the entirety of it goes, then there's no provision for disqualification.
That Parliament will have to make one. That's if the Parliament wants to deal with morality in politics, they will have to make this. This has to be done. Now, how it make it, what is the contours of that
You don't have
legislation?
to go to the extreme of, yeah.
No, I'm not. I'm only saying, Manoj, I'm only saying to your lordships that this is the,
Nabam ka theek hai.
Well,
We'll
let's
deal with-
draw a line there, Mr. Sibal, or else it will become unending.
It will become,
Unending.
and there has to be some constitutional certainty also. I mean,
no, but then you must be lay down a law, Manoj, that there is some certainty, because otherwise, Manoj, what is happening is, Manoj, that these matters are never heard. Your lordship knows adjournments are granted every week, Manoj, for years. For years, these matters are not heard because the speaker is sitting there. And we come to court and the court doesn't.
But therefore, your argument on Nabam really is that the constitutional scheme does not contemplate the disqualification of the speaker merely on the issuance of a notice, or for that matter, even upon the grant of leave according.
That's right. That's right.
81.
Yes, 181. At any sitting of the Legislative Assembly, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside and the provisions of clause 2 of the Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker or, as the case may be, the Deputy Speaker is absent. The Speaker shall have the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly while any resolution for his removal from office is under consideration in the Assembly, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of an equality of votes. 189 says that if there is equality of votes, then the casting vote is with the Speaker. But when his resolution for his removal is in consideration, he can only vote in the first instance.
When do the words under consideration kick in?
Kick in at the time when the motion is moved for consideration.
Is that so, or does it kick in the moment leave is granted to move a resolution by 29?
No. But the resolution may not be moved, as I said. No.
It still remains under consideration.
Yeah, because then he can't be the Speaker, Manoj. Then how can he sit on that chair?
No, he can't be the speaker in the meeting, correct? Or the day on which the actual resolution is taken into consideration.
Yes.
Taken up for consideration.
Absolutely.
That is what you're submitting.
That's right.
Otherwise, under Rule 11, he cannot act.
Because otherwise he can't act, grant leave. He has to be
clause
by him.
2, interestingly, both clause 2 and clause 1 use the expression under consideration.
Yes.
Now, conceivably, the word under consideration in clause 1, words under consideration in clause 1 may not only be relatable to the date on which the resolution is taken up for consideration. That's right. In clause 1. But in clause 2, it is obvious that the words under consideration operate on the date when it is actually taken up for debate.
That's right.
So the question is whether we should therefore expand clause 1 and say that under consideration in clause 2 relates to a different point of time than in clause 1. That's a possibility.
Well, it's my respect for...
According to you, should be the same.
I'll tell your lordship why. The word consideration is not a word of art in clause 1. It is a word which relates to the procedure of the House. It's not a word of art.
Because
under consideration
says that you have a right, he has a right to speak when it is under consideration.
Yes.
Now, his right to speak is on the motion when it is.
That's correct.
Therefore, according to you, under 1, where he is not entitled to preside, this will attach on the date when the motion is taken.
The reason is, Manoj, the word consideration is used in the context of procedure when his removal is being considered.
So according to you, therefore, even when leave is granted, at the stage of the threshold of leave is crossed, even then he can really preside.
There's a judgment, Manoj, of the Allahabad High Court to that effect, which I showed to your lordship.
The word sitting.
It goes with the word sitting, Manoj.
Is this scheme of 179 and 181 any manner affected by the 10th schedule?
No. This is our case, Manoj. It can never be. These are proceedings in the House. These are legislative proceedings in the House.
The 10th schedule is silent on what happens when there is a notice.
It can't, Manoj. In fact, the 10th schedule, there can be no pause, Manoj, because it's a constitutional authority. There can be no fight. As I said, Manoj, that's the base. It's a fundamental principle of constitutional law. Whether it's the Election Commission, the government, the Speaker, Manoj, the courts, there can never be a pause. It's anathema to constitutional...
Relating to the presiding officer of the tribunal's competency.
Yes.
They only relate to those two.
Yes.
So 10th schedule to that extent will have no bearing.
Doesn't apply. Because it's in the House. We're talking about his removal from the
The
House.
presiding officer. It's about his...
The flip side, if we permit a speaker, now you're assisting the court as counsel.
Yes.
It's not really...
Yes, of course.
Because we are looking now at a broader constitutional issue. What would be the consequence if we allow a speaker to participate? There are two stages, right? One, just the notice. The notice is, of course, it can be given even by one person. What would be the consequence if we don't allow the speaker to take action the moment a notice of resolution is issued? That, according to you, would result in a very serious consequence. But on the flip side, what would be the consequence if we allow the speaker to participate even when the stage of, say, the grant of leave is crossed? What would be the argument on the flip side?
No, but there have to be 29 members have to support that. He cannot decide.
No, 29% MLAs have already supported, and the leave is granted.
If they've supported, and leave is granted,
Correct.
and leave is granted, then the day
Mr.
Chief is-
My
What
learned
Chief
brother will explain what was falling.
was asking you is, what will be the consequence of the speaker continuing to decide the 10th schedule proceedings while a proceeding is pending after issuance of the notice?
as I said, as I said,
That's the question.
yes, as I said,
Other line of, this should be seen in the context of other line of judgments on the 10th schedule, saying why is he in such a hurry to decide? There must be sufficient time.
let me, Millet, answer that straight away, Millet. Now, you are interpreting 179 to mean that the speaker will continue to discharge his functions as a speaker till the motion for his removal is put to vote. The purpose of
Correct.
Correct, Millet? He has no disability. Correct? And till it is put to vote, the motion may never be moved. May never be moved, Millet.
So,
Mr. Sybil, what is worrying me, of course, is, sorry, Nasma.
No, go ahead.
What is worrying on the other hand is this, he's just putting it to you. On the other hand, if you say that, well, he can take all action, including on deciding on disqualification, until the motion is put, the day is put to vote, the consequence then may also be this, that he can affect the motion for his own removal by deciding upon the disqualification.
I tell you, Lordship,
That's so desirable.
No, that I tell you, Lordship,
That
there's a difference there. There's a difference there. Miller's, his removal by the House, not subject matter to challenge. The legislative process. Internal to the House. A disqualification in the same schedule, subject matter of challenge. Judicial.
Person is wrongly disqualified.
Right, person is wrongly disqualified, your lordships have so often intervened. Set it aside, you can go back.
But of course, therefore, then we'll also have to factor in. The sense of your submission is that though a speaker then can, by deciding upon the disqualification issue, essentially affect the course of his own removal.
No, but that is your lordship is assuming that he will discharge his functions in a malified ML. That's your lordship have to make that constitutional assumption. And the whole purpose of Geruto Holohan.
Ultimately, that was the whole basis of your initial submission.
No, because I am being an arbiter in these matters at all. So that's another matter. That's nothing to do with it.
The only thing which seems to have reached the court is that's really, otherwise constitutionally your argument is, I mean, obviously, prima facie, your argument on reading 179 and 181 are very clear. But now the only point is this, that by giving the power to a speaker, are we then going to essentially give the speaker the ultimate power to decide upon the course of his own removal?
No, it's not the course of his own removal, it's the course of the removal of those who have actually voluntarily given up membership of the party. This is not a question of course of his own removal.
Yeah, that's
Because he belongs
That will tilt the balance.
I'm sorry?
That may tilt the balance.
But it will, if they have voluntarily given up, it will tilt the balance. Why should it not tilt the balance?
Decided.
Why should it not tilt the balance? If actually, kindly forget about, now let's go into just a short summary of facts. In this case, what happens? In this case, what happens is this notice is given. This court says they can reply by 12th of July.
right.
And the government falls in the meantime. And we are 8 months down the road. He has not even given notice on our disqualification petitions.
Move the notice.
No, the person has not moved the notice and the speaker has not given a notice on disqualification petitions. I mean, you have seen the
So according to you, the speaker was well within his right to disqualify anybody in the meantime as well.
because of the facts which are undisputed. You had a new government with the support of these people. What else is it but voluntarily giving up membership of the party? And then, Manoj, if the argument is he is going to decide his own fate, no.
Now, Mr. Sibal, we saw the first part of Nabam Rebia where Justice Keir puts it as a matter of ethical grounds. Now, how does he interpret?
Yes, I was going to read that.
Well, let's just
we'll
read
go
that.
that. We'll go
So
further.
that's the next step to cross on Nabam.
Yes, absolutely.
I didn't want to interrupt the speaker. They said that the fresh disqualification notices after the new speaker took over were not issued for 8 months because during that hearing in the Supreme Court, everyone decided that while your lordship are seized of the matter, the speaker would not precipitate the matters or proceed further. So to say that he did not act on those notices is completely incorrect because that was something which was agreed to by the parties. What was not agreed to by the parties was EC being injuncted, which your lordship decided. But the other issue was when we all were here, we all were ad item on the fact, let it not be precipitated. It's a very wrong impression being given as if the speaker has been sitting and not even issued notices after that.
Because he issued notices against us. He said, we should notice again, despite what my learned friend is saying. So what's the point of this kind of interjection? He selectively issued notices. There was no bar as far as he is concerned to issue notice to us. But there's a bar as far as notice to their own people. What kind of intervention is that?
To both the
Anyway, one second.
Both parties.
Now, let's, Mr. Sibal, for a moment, we're not clouding our mind on the correctness of Nabam, on the facts of this case. That would be a very improper. We must look at it straight on as a constitutional issue.
Yes, I agree, Manoj. I'm only saying, yes, absolutely. If you're, Manoj, the point is there are two. Later, Manoj, they are also interpreting the word then members of the Assembly.
Yes.
And you'll have to look at that. Manoj.
Let's see that now.
Yeah.
Para 190 and
190. Manoj, let's read that first.
That's the only ground of.
Yes, that's the only ground. Which is also, according to me, constitutionally erroneous. But we'll argue that later. Just like the other provisions of the Constitution interpreted by us here in above, it would be apposite to ascertain the desired intent of the framers of the Constitution emerging from the Constituent Assembly debates with reference, I'm sorry, Your Lordship had that?
yes.
Para 190. With reference to Article 179C. In the draft Constitution, the present Article 179 was numbered as draft Article 158. One of the issues debated with reference to draft Article 158 small c was with reference to the words, quote, all the then members of the Assembly, unquote, used therein. The above words were used to define those who would participate in the motion for the removal of the Speaker. Needless to mention that the said words were retained in the final draft in Article 179C. One of the members of the Constituent Assembly had suggested substitution of the above words by the words, the members of the Assembly present and voting, as under CAD volume whatever. Muhammad Tari, sir, I beg to move that in clause C of Article 158, for the words all the then members of the Assembly, the word the members of the Assembly present and voting be substituted. In other words, the majority not be counted in the context of all the members of the Assembly, but only those who are present and voting. There, sir, as far as I can understand, the meaning of the wording, all the then members of the assembly, it includes all the members of the assembly. Supposing a house is composed of 300 members, then it will mean all the members of the assembly, that is 300. Supposing 50 members of the house are not present, then those members will not have the right to give their votes as far as this question is concerned. Therefore, I think it would be better that this matter should be considered by only those members who are present in the assembly and who can vote in the matter. In this phrase, all the then members of the assembly means the members who are present in the assembly. Then I have no objection. If it means all the members of which the house is composed, I think it is not desirable to keep the clause as it stands. With these few words, I move my amendment. The Constituent Assembly debates do not appear to have recorded any discussion on the above amendment. The decision on the proposed amendment was, however, minuted under so-and-so. Mr. President, the question is that in Clause C of Article 158, for the words all the then members of the Assembly, the words the members of the Assembly present and voting be substituted. It is apparent that the Constituent Assembly chose to retain the words all the then members of the Assembly and declined to substitute them with the words the members of the Assembly present and voting. We are of the view that the acceptance of one set of words and the rejection of the suggested substitution would effectively render a constitutional answer to the issue. Article 179C provides that a speaker or deputy speaker may be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. A notice of resolution for the removal of the speaker or the deputy speaker of the Assembly would therefore have to be passed by a majority of all the then members of the Assembly. The words all the then members included in Article 179C are a conscious adage. If the words all the then members were excluded, then Clause C of Article 179, it would have that.
This really means all the members of the assembly means
That's right.
that you have to meet a higher threshold.
Correct. That's like in the judges removal, brother. The
If you
judges
have a
removal.
300 have a motion for removal passed, you must have 151.
That's right.
But what it means is that instead of 300, you have say 90 present that day, and people are not well.
Still 151 will have to.
Still 151.
Absolutely.
50% of 190.
Correct.
So the threshold required is given the strength of your assembly.
That's right.
All that is.
This is the constitutional logic, Mullah, that they have used.
They say that, well, because the constitutional provision says all the members of the, that means that the speaker has no power to decide upon the disqualification only, not according to the secretary.
Doesn't seem to be constitutionally
And
logical. Mullah, for example, when a judge is removal.
because you can't compel a member to attend.
Yes, yes.
Suppose somebody is down with a serious medical issue.
No, not only that.
Doesn't require a disqualification.
Not only that, how do you bring back a man who has died?
As of that date.
You can't bring him
There would
back.
be a vacancy.
Then members, he is frozen. Unfortunately, you can't bring him back. No matter how we think. So you can't bring him. A man who resigned. How can you prevent a resignation? The freeze on the date of the notice, you can't freeze the numbers of the house. So completely.
Read further, Mr.
Yes, I'll read further. So Mother's,
This is, I think, the only paragraph.
then members excluded from clause C, it would affirm the interpretation of the appellant. The connotation placed by the appellant would legitimize the action of the Speaker in going ahead with the proceedings under the 10th schedule, even though a notice of resolution for his was pending. The words "all the then members" consciously added in 179, and this substitution was not accepted by the Constituent Assembly. We are satisfied with the words passed by the majority of all the then members of the Assembly would prohibit the Speaker from going ahead with the disqualification proceedings under the 10th schedule, as the same would negate the effect of the words "all." After the disqualification of one or more MLAs from the House, the words "all the then members" demonstrate an expression of definiteness. Any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of resolution of the Speaker or Deputy Speaker is pending would conflict with the express mandate of 79C, requiring all the then members to determine the right of the Speaker to continue. It would also be relevant to notice that the 10th schedule was inserted in the Constitution by the Constitution's 73rd Amendment, Act 1992, with effect from 24/1990. Well, this is also wrong. It is by the 52nd Amendment, not the 73rd, introduced in 1985, not 1993. This is also somehow error is.
Next para. No, next.
The purpose sought to be achieved through the 10th schedule is clear and unambiguous. The same is unrelated to and distinct from the purpose sought to be achieved through Article 179C. Neither of the above provisions can be seen as conflicting with the other. Both must therefore freely operate within their constitutional space. Each of them will have to be interpreted in a manner as would serve the object sought to be achieved, without spreading into the constitutional expanse of the other. The interpretation would have to be such as would maintain constitutional purpose and harmony. We would now venture to examine the issue, the above perspective in the following. Now, if this is right, if
193 also. Next para also is.
Yes. If the Speaker survives the vote on the motion for his removal from the office of the Speaker, he would still be able to adjudicate upon the disqualification petitions filed under the 10th schedule. The process of judicial review cannot alter the above position. But if a disqualification petition is accepted by the Speaker, the disqualified MLAs will have no right to participate in the motion moved against the Speaker under 179C. A disqualified MLA, as we all know, can assail the order of his disqualification by way of judicial review, which is what I was saying, Melissa. If he succeeds and his disqualification from the House is set aside, such a disqualified MLA would be deprived of the opportunity to participate in the motion of the Speaker under 179C. In this situation, the process of judicial review can also alter the position if a disqualification order passed by the Speaker is set aside by a court of competent jurisdiction. In the event of an MLA having been disqualified by the Speaker, the notice of resolution for the removal of the Speaker would surely be dealt with and will be disposed of during the period when the MLA concerned is disqualified. Alternatively, if an MLA has not been disqualified, when the motion for removal of Speaker is taken up, he would have the right to vote on the motion pertaining to the removal of the Speaker, whereafter the petition for his own disqualification would certainly be considered and decided by the Speaker. It is apparent that the difficulty arises only if the disqualification petition is taken up first and the motion for removal of the Speaker is taken up thereafter. That is where that comes from. The possibility of a disqualification petition being decided on political considerations rather than on merits cannot be ignored. This works both ways. Doesn't work one way. In fact, that is a real possibility. Therefore, while it will not adversely affect the Speaker if he faces the motion of his own removal from the office of the Speaker before dealing with the disqualification petitions, it could seriously prejudice MLAs facing disqualification if petitions for their disqualification are taken up and dealt with first. The adoption of the former course would also result in meaningfully giving effect to the words "all the then members."
So everything comes down to all the then members.
That's correct. That's correct.
The last three lines also.
Members used in the Article 179C, as discussed in the foregoing paragraph. This interpretation would also purposefully give effect to the rejection of the amendment suggested during the Constituent Assembly debates that the motion for removal of the Speaker should be the majority of the members of the House present and voting. This interpretation would also result in disregarding the retention of the words "all the then members of the Assembly" in Article 179C. If the Speaker faces the motion of his own removal first, both the constitutional provisions would have their independent operational space preserved. None of the constitutional provisions concerned would interfere with the free functionality of the other, nor would one usurp the scheme postulated for the other. We're therefore of the view that constitutional purpose and constitutional harmony would be maintained and preserved if a speaker refrains from adjudication of a petition for disqualification under the 10th schedule, whilst his own position as the speaker is under challenge. This would also allow the two provisions, 179C and the 10th schedule, to operate in their individual constitutional space without encroaching on the other. For the reasons recorded above, we hereby hold that it would be constitutionally impermissible for the speaker to adjudicate upon disqualification petitions under the 10th schedule, while a notice of resolution for his own removal from the office of the speaker is pending. And Manoj, we have in our note, and I will show that to your lordships presently, there are other provisions in the Constitution where the expression "then members" is used.
Actually, this.
And Manoj, that has been interpreted.
No, actually, as Madan Lokur's judgment says.
I can't hear you.
As Justice Madan Lokur's judgment says, this was not necessary also to decide.
Exactly. It was not
Because it was
necessary for the case. I don't know why the judges went into it, because Justice Mishra, I was in that matter, raised this issue on his own and said we must also look at it.
Really, 9th December 15th decision of the governor was the real.
That's correct. That's set out in the first paragraph of the judgment itself. It's really all arbiter. It's really not.
But he preponed the
Yes.
meeting.
Preponed and sent a message saying how you will consider. So both the message was struck down and Manoj, the preponing of the session was struck. That's what really happened.
Of
This
course,
really
the
was.
subsequent decision of the deputy speaker reversing the speaker's order.
That's right. And declaring that
was
to be
another.
void. That also. But the disqualification matter then went to the Guwahati High Court, Manoj, and there they were decided one way or the other.
Initially, legislature stayed the entire proceedings.
Correct. So the issue, Manoj, the issue is simple. Assuming, let's put it, your lordship was Manoj putting to me that you are also concerned with the other aspect as to why he should be allowed to continue. Let's assume he is not allowed to continue. But who will then decide under the 10th schedule? The petitions are pending, no?
But on facts of the present case, is it because of the principle in Nabam Rebia that the problem has arisen for you, or is it just that the judgment is wrongly decided and referred to the large implication on your case?
The implication is very serious because on 27th, because of these
Give us
two
the
arguments,
What are the dates of your?
I'll just tell you, lordship, briefly orally. On the 27th, when this was passed, the order saying, give them till 12th of July. Until 12th of July. Then, Manoj, obviously, these people were legitimately members of the assembly. So then they, Manoj, went to the other side, and the new chief minister was sworn. Manoj, in fact, an elected government was toppled through this procedure.
Right. Now let's see how Justice Mishra deals with.
Yes, Justice Mishra also.
Yes.
Yes.
And then Justice Malik.
That's correct. One 1146.
This is Narasimha's theory, the foundation of the import order in this case, when it's got is Nabam Rebia, mentioned. And thereafter, the entire notice disabling is based on that.
See.
Foundation is that.
1142.
46. Yeah.
No, PDF. Tell us.
115. PDF 1146 will be there.
Mishra.
Yes.
What is the para number?
Yeah. Sorry. Sorry. Yes.
Are you referring to Justice Mishra's calculation?
Yes.
Okay, para 216, shall I say 215?
He quotes Article 179.
Yes, 215.
And then at 218, Mullahs, he starts discussing, if I may read that.
115 PDF.
The thrust of the matter. Para. The 217, Mullahs, the learned judge quotes 179.
Yes.
The thrust of the matter, if your lordships have it, thrust of the matter is what interpretation is to be placed on Article 179C and the first proviso. Being diligently and respectfully adherent to the norms of constitutional interpretation, I may state with quite promptitude, purpose of adherence should not convey that one can find any kind of static principles that flow from our again by text and passionate constitution. Passionate is a very form. Politics is always lack of your constitution. Anyway, there are presidential guides, and if I allow myself to say constitutional precepts, to serve as a light posts without causing any violence, even remotely, to the language employed. Then Malaji quotes Karnataka. Let's go to the minutes out. Your Lordship want me to read? I will read, but I don't think it's.
No.
In verse 220, the aforesaid paragraphs clearly convey that judicial interpretation cannot nullify or distort the constitutional provision of the interpretive process, cannot in direct conflict with the express provision of the Constitution. However, the learned Chief Justice has observed that constitutional document has to be read as a whole and construed keeping in view the declared objects and functions. In the said judgment, a distinction has been drawn between constitutional law, the fundamental law, the laws which may be important constitutional matters. I think it appropriate to reproduce. When those passages are reproduced. Well, it's para 223. With giving the Constitution a purposive interpretation, and it just relies on all those judgments. Then 223 paragraph. I have referred to the aforesaid pronouncement as they have laid down the guidelines for the text, context, the words and the purpose of a Constitution. Emphasis is on flexibility, adaptability, and durability, and also not to import or implant an interpretation which would be in conflict with the express language of the Constitution. Having received the guidance from the precedents and keeping in view the cohesive constitutional precepts, I shall proceed to analyze the language of 179C. Prior to that, I think it convenient to dwell upon the importance of the office of the Speaker. There is no shadow of doubt in my mind that to appreciate the significance of the provision, namely 179C in the context of constitutional supremacy and constitutional consciousness, it is necessary to understand the position of the Speaker. The Constitution. Office of the Speaker in our history had its origin in 1921. The Legislative Assembly was constituted. Mategu Road reform. That time, Office of the Speaker did not enjoy much importance, but a significant one after the Constitution came into force, as is evident from the constitutional scheme of ours. The Speaker enjoys high constitutional status, and the Constitution reposes immense faith in him. For this reason alone, the Speaker is expected to have a sense of elevated independence, impeccable objectivity, and irreproachable fairness, and above all, absolute impartiality. This expectation is a constitutional warrant, not a fond hope, an expectation of any individual or group. The Speaker has the duty to see the business of the House is carried out in a decorous and disciplined manner. The functioning requires him to have unimpeachable faith in the intrinsic marrows of the Constitution. Constitutionalism and rule of law, the faith, needless to emphasize, should be visible and apparent. That is why possibly former Speaker of the House of Commons in the UK, Baroness Boothroyd, when you have been committed all your adult life to the ideals and policies of one party, impartiality is a quality that you have to work at. But if you cannot put aside partisanship, you have no right to even think of becoming the Speaker. I have referred to the aforesaid only to stress upon the impartial functioning of and constitutional neutrality of the Speaker. The expression can be different. One wishes to choose the ancients. The ancient wisdom would require the Speaker to abandon his Ram and get wedded to Parashram. To elucidate, a Speaker has to constantly remain in company with the cherished values of incarnation of his office and not deviate even slightly from the constitutional conscience and philosophy.
Actually, para 233 and 235.
That's right.
233 is the real para.
Notice how far removed are these words from reality is something that we can take notice of. 233. 233, Manoj?
Yes.
There can be myriad situations of democracy. The Constitution as an organic instrument has to be interpreted to meet all exigencies. It has to have the resolution for removal of the Speaker the office immediately to the Speaker on a complaint initiates action under the schedule. As the resolution against the Speaker cannot be moved unless 14 days expires. Notice period expires, the members can be disqualified within the said period, and the Speaker would gain an advantage. Thus, it can result in a situation of conflict, that is, conflict between the status of a Speaker conferred by the Constitution, the position he has been after the constitutional amendment. The final arbiter have trusted him regard being had to his constitutional status. It is the constitutional trust, therefore, there should be perceptibility of absence of conflict. That apart, it will not be in harmony with Article 179C or the constitutional norm. It would also cause discord with the language employed in the said article. The founding fathers had deliberately retained the words "all the then members" by negativing the proposed amendment. The purpose of not accepting the amendment is to preserve the constitutional control over the situation. In this regard, I may usefully refer to 189 of the Constitution. It provides for voting in houses, power of houses to act notwithstanding vacancies in quorum. Clause 1 of Article 189 stipulates that, save as otherwise provided in the Constitution, all questions at any sitting of a House of the legislature of a state shall be determined by a majority of the votes of the members present and voting, other than the Speaker or Chairman or person acting as such. The said clause also provides that Speaker or Chairman or person acting as such shall not vote in the first instance, but shall have the exercise of a casting vote in the case of equality of votes. The said clause thus clearly states that the majority of votes of the members present and voting, and secondly, it empowers the Speaker to exercise his power of voting in case of equality of votes. In contradistinction to the same, 181 provides that the Speaker or the Deputy Speaker is not to preside while resolution for his removal from office is under consideration, and he is entitled to vote in the first instance on such resolution, but not in the case of an equality of votes. Article 181(2), which is relevant for the present purpose, reads as follows. We've read that. The purpose of referring to the said article is to highlight the nature of participation of the Speaker when the question of his removal arises. It is clearly different. Under the Constitution, he is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution, especially keeping in view the language employed in the first proviso to Article 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest till the resolution is moved. In this regard, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers to the Speaker while deliberating on the constitutionality of the said schedule. The majority in so and so has stated and follows. Losses may leave that, we know. Then verse 237. The aforesaid reasoning eloquently speaks of the power, position, and status of the office of the Speaker enjoys under the Constitution. It also states that the scope of the fiction, the court has constricted the power of judicial review to restricted it, each carving out certain extreme exceptions. It is because the Speaker, while exercising the authority, jurisdiction exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional value sustains democracy in a sovereign republic. The Speaker is expected to maintain propriety with an adjudicator. The Speaker, when functions as the tribunal, has the jurisdictional authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, such impartiality should be perceptible, be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of the 10th schedule by constitutional amendment is required to be harmoniously understood. 79. Provisions of the Constitution are meant to subserve the purpose of sustenance of basic features of the Constitution. Speaking of democracy in India as a product of the rule of law is only a political philosophy, also an embodiment of constitutional philosophy. Thus, regard being had to the language of 179C and the role ascribed to the Speaker, it is necessary that the Speaker of the tribunal have complete and procedural. When there is an expression of intention to put the resolution removed, it is requisite and then proceed. That is the intent of 179C. Said interpretation serves the litmus test of sustained democracy founded on the rule of law. Founding fathers had so intended and the constitutional value, trust, and morality unequivocally, so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the schedule. After intention to remove him is removed. 14 days period being mandatory, the words all the then members gain more significance. The Constitution is confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the can't have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution. Clearly brings in harmony between constitutional confidence or trust and the constitutional control. It is stated the position has to remain the same even after introduction of the 10th schedule to sustain the robust vitality of our growing constitution. It embraces the seminal spirit of the rule of law that controls all the powers, even the prerogative power. Before parting, I say that the constitutional restraint and discipline are revealed from the words of the Constitution and the high constitutional functionary who should remain indebted to the with humility, because it is humility that forms the foundation of regard, which is the ultimate constitutional virtue. Nonetheless, all that the learned judge has said is contrary to judgment after judgment by this court, saying just the contrary. That we have seen speakers behaving in a particular fashion. We have seen the manner in which they have conducted themselves. Actually, it is Parliament who must change this system. I'll give those judgments to your lordships.
Now let's see Justice Lokur. So,
Yes, Justice Lokur.
Justice Mishra again refers to the words of all the members, all the then members of the
That's again the same thing.
He also places it on the ground that, there must be an impartiality of the Speaker. So the moment there's an expression of an intent to remove him or them, he should first stand the test. So the moment, in fact, that means that Justice Mishra even goes as far as to say that the moment a notice is given, the initial notice, because he felt that otherwise what will happen is within the 14-day period for the notice, the Speaker would remove these people, disqualify them.
That's right.
And that would affect the impartiality of the Speaker. He places it on the ground of constitutional trust.
More than the interpretation, he is on the ground that impartiality of the Speaker.
Because within that 14-day period, if the Speaker is allowed to disqualify, that would affect his own impartiality. Because as an arbiter under the 10th schedule, he has to be impartial. That's what that's the constitutional theory with Justice Deepak Mishra.
Well, it's like saying, if I'm holding a constitutional office, then there's an expectation that I will be impartial. Now, the underlying this is the expectation that he will not be. That's the underlying theme of Justice Mishra's.
What does Justice Lokur say? Let's see the
Yes.
242.
4042.
401.
4242. PDF 1224.
1224 PDF, Malaz. Paragraph 401.
To navigate. One.
No, para 396, I think.
Yeah, 396.
396.
Question here. 396. My Lord Justice Shah.
Chief,
Which one?
23. 1223 PDF.
1223. Yes.
The question here is not whether the disqualification of 14 members of the Assembly is valid or not. That was a matter pending consideration in the Guwahati High Court, when the judgment in these appeals was reserved, but has since been decided. We're not concerned with the decision of the Guwahati High Court or the power or propriety of the decision of the Speaker. The narrow question is whether the Deputy Speaker could, by his order dated 1512, set aside the order of the Speaker, also dated 1512, disqualifying 14 members of the Assembly, including the Deputy Speaker. The Speaker gave notice to the 14 members of the Assembly on 7/12, them to show cause why they should not be disqualified. Under the 10th schedule, thereafter, by an order dated 1512, Speaker disqualified them from their membership in this Assembly. As mentioned above, the correctness of this order and the procedure followed has now been decided by the Guwahati High Court, and the correctness of that decision is not before us. Speaker passed an order of 1512 inter alia on the ground that the Speaker lacked the competence to pass the disqualification order and that he had not followed the constitutional and legal procedure of his removal. He had lost his competence to pass the disqualification order since a notice of removal dated 1911 was pending. was come up before the Legislative Assembly on 1612. In passing his order on 1512, the Deputy Speaker purported to drive his power from the message given by the Governor to the Legislative Assembly, requiring the Deputy Speaker to conduct the proceedings of the House on the resolution for removal of Speaker. What is important to note is that the Deputy Speaker was to preside over the House on 1612. He certainly had no derivative power from the Governor dated 9/12 to take over the functions or to sit in judgment over the decision of the Speaker. That apart is now well settled by the decision in Kyoto that the Speaker, while acting under the 10th schedule, acts as a tribunal and his decision can be challenged only in a court exercising constitutional jurisdiction. It was held in Kashinath that even the Speaker does not have the power to review the decision taken by him under the 10th schedule of the Constitution. Under these circumstances, there is absolutely no question of the Deputy Speaker setting aside the order of the Speaker passed under the 10th schedule. It is also important to note that the Deputy Speaker himself disqualified from the membership of the Assembly by the Speaker, and he could certainly not have set aside the order passed against him and in respect of which he would be the beneficiary. There is no doubt that the Deputy Speaker had no authority at all to set aside the decision of the Speaker passed under the 10th schedule. The fifth question is answered in the negative. In view, I am of the opinion that the view expressed by my learned brothers relating to the power of propriety of the Speaker taking a decision under the 10th schedule with regard to 14 members does not at all arise in these appeals. Well, let's look at another scenario. A notice is moved both against the Speaker and against the Deputy Speaker. It can happen, Manoj. So, Manoj, both will be disqualified. Then what happens to the 10th schedule? So this has far-reaching consequences on how our democracy is going to function in this country. And your lordships put it to me that the other concern is that he should not decide because he may be deciding in his own interest, Manoj. That's what your lordships put to me. But Manoj, the question is that as far as that is concerned, it is subject to judicial review. And the judiciary, if it says that he is wrongly disqualified, they'll be back in the House. And you can move a fresh motion.
But in the meantime, what will happen?
Nothing, you move a fresh motion.
If the disqualification is set aside,
yeah.
What will happen? What will the consequences?
No, they will come back. They will come back and move.
It presupposes that it is decided within reasonable time. But supposing the court, it takes time. Correct that. What will be the position?
No, that's
the interim period.
No, that's for
the
courts.
Government will be.
I would request your lordships to not assume that courts will take. Courts should not. This is our refrain has been throughout the last so many years that courts are taking time. Sometimes the court sits day after day to discuss what's happening in Rajasthan. When it then comes to Goa and to some other assemblies, it takes years to decide. It's for the court to decide, not us, Manoj. We expect the court to take up the matter immediately. But courts don't, unfortunately.
No, we are not on that. We are on the consequences.
But the point is...
Not sufficient that it will be set aside.
Yes.
And then will be set aside. But what will be happening in between?
But that happens in every case of disqualification, Manoj. Why should this be different? Let's forget about this issue. In every case of disqualification, Manoj, he'll come back. What's the difference in that consequence and the one that your lordship is asking me? No difference.
Actually, Mr. Sibal, then your broader principle is this. That is a matter of constitutional principle.
Yes.
A constitutional authority continues to act as a constitutional authority unless the Constitution treats the authority of that constitutional authority as having come to an end.
Correct.
Namely, after the motion of removal is passed.
Correct.
Until a motion of removal is passed, there is no cloud on the functioning of a constitutional authority.
That's right.
And unless the Constitution has imposed any express or implied restraint, that should not be read in, because he for all purposes continues to perform all the functions of a speaker until a motion for his removal is passed.
Yeah. Manoj, how is the 10th schedule in any way, Manoj, derogatory to what is happening in the House under 179C for a removal? Manoj, the court has at two places remarked that these are two independent functions. Your lordships have seen that?
Yes, constitutional space has been.
Yes, there are entirely different spaces.
There were only two principal arguments, and the two principles which held favor with Justice Keir and Justice Mishra eventually. One was the expression,
Then
members of the Legislative Assembly, which is really on a completely different issue. The second is something which requires a little more, deliberation, which is Justice Mishra's position that if you don't read this restraint, then within that period of 14 days, that is mandatory for the removal, Speaker could, by the exercise of the qualification, to conduct the outcome of his own, which your answer that, look, the Speaker's decision to qualify judicial review. Whereas
there is no
a motion for the removal of a Speaker is not a.
And there is no constitutional assumption, Manoj, that we can make as a matter of law that the Speaker will act in his own interest and not in the interest of what is set out in the 10th schedule. You can't make a constitutional assumption of that nature. Either you say that the Speaker belongs to a political party, we know. The Speaker does not resign from that political party, we know. And yet we don't ever make a constitutional assumption that he's acting in favor of that party. We never make that. In ordinary cases, forget about this. Do you ever say that? No, never. Why? Because he's a constitutional authority. The 10th schedule has empowered him to perform that function. The constitutional assumption is that he will not be swayed by party consideration. That he is maybe a fact. But constitutionally, you cannot assume.
One thing is very clear now, that para 193 of Justice Kehar's judgment and paragraph 238 of Justice Deepak Mishra's judgment, both the learned Chief Justice then were, make it very clear that according to them, once a notice for resolution of the removal of a Speaker is pending, a notice of the resolution for removal, then the Speaker cannot act.
That's correct. That's correct.
It's very clear.
That's correct. And that is based on, except that notice can happen. They don't fix the time when that notice takes place.
And logically, they are right in the analysis which they do, because they don't then bifurcate between the stage prior to leave being granted and after leave being granted.
That's correct.
So they know that, well, the judgment, they're very clear that it relates the disqualification on this, or the disability on the Speaker entertain a disqualification petition attaches the moment a notice for the removal is.
That's correct.
They don't then bifurcate it at the stage when leave is granted.
No, either they don't. They don't, which is the rules bifurcate.
Yes.
The reading of the rules bifurcate the manner in which this is to be considered. And they don't even tell us at what stage the notice is to be moved.
And the Speaker is not, according to, he doesn't cease to be a Speaker merely by a notice of removal given to him.
Correct.
Therefore, should the Constitution should it be interpreted to know that
The restraint
or disability or a cloud on his because of the fact that a notice for removal is given to him.
And as I said, Manoj, there are the other parties, Manoj.
Really, it's a matter of interpretation. It's very short.
And there's the other issue, Manoj. There may be several petitions.
So anything else on the issue of, you've argued your point for reference, Mr. Sibal, anything else? So that
No, Manoj, I'll just quite quickly, because there are some things that I have to point out. I've written submissions, I'll quickly read through them and then.
We can look at it. We can examine.
Right.
Now we are now looking at the other aspects. We come back after lunch.
Yes.
That we can. You will only focus on your submissions. How long now for you? It's about.
It's not too long, Manoj.
Your submissions with respect to reference.
Sorry?
Your submissions with respect to reference to larger data.
Reference one.
Yes.
That's all.
You know.
That's only reference. I'm not on the argument. Because if your lordship then decides to refer.
Mr. Sibal, just for a little clarity, you don't have to spoil your lunch because of this last question. Ask one of your juniors to give us just on a piece of paper the facts in Nebam Rebia. Just
we've done
bullet point, just bullet points on the facts.
We've done that.
Just to have a little clarity, because we're now looking at the facts by reading the judgment.
We have already filed
just on a paper.
additional compilation. One pager is already there.
All right, just that one pager we'll see, and then we'll go on to
Yes.
and then we'll call upon the others.
Yes. Deeply obliged.